Well, I'm just outside Hammersmith Magistrates Court, about to go in to face trial for obstructing the highway, or allegedly obstructing the highway, back in June during an anti-MGM protest in Parliament Square. I believe we have a very good legal defence, which I shall be explaining after the trial. And I thank Ian very much for helping me develop that. He'll hopefully be here shortly to sit next to me in court and possibly give some advice. So really this is a trial about what's reasonable to do to bring to public attention the illegal practice of non-therapeutic male circumcision or male genital mutilation, and I'm going to give this the best shot, whether I'm found guilty or not. Time will tell. Okay. Right. I'm here outside Hammersmith Magistrates Court. My trial for obstructing the highway has just finished, and before I give you the verdict of the judge, the lady judge, I'd just like to read out the statement that I read to the court. I'm pleading not guilty today because I had a lawful excuse for being in the road on the 1st of June during a large demonstration in Parliament Square against the circumcision of male minors. Before I outline that legal excuse, I need to provide some background. I'm the leader of the political party Justice for Men and Boys, the only political party in the English-speaking world campaigning for the human rights of men and boys. In the UK today, there are at least 20 areas in which the state assaults the human rights of men and boys, usually to advantage women and girls, and no areas in which the state specifically assaults the human rights of women and girls. None. For many unfortunate males, the assaults start early in life with circumcision on non-therapeutic grounds, often on cultural or religious grounds. At 8 days of age in the case of one religious tradition. I'd like to quote a few words spoken by a prominent barrister at a conference in 2013. The default position of the criminal law is that circumcision is a crime and it requires a parliamentary override to stop it being a crime. There is no such parliamentary override. End of quote. In plain English, circumcising male minors on non-therapeutic grounds, often called male genital mutilation or MGM, is a criminal offence. However, the criminal justice system doesn't prosecute those carrying out the crimes. We estimate some of these criminals earn over £2 million over their criminal careers. You may be aware of the principle, or you will be aware of the principle, that religious or cultural considerations cannot override the law. So the fact that the practice is endorsed by adherents of Judaism and Islam is of not the slightest legal consequence. Circumcision of male minors is also a breach of several articles of United Nations and European Union human rights conventions. Ethicists at Oxford University and elsewhere have described it as being equally as unethical as female genital mutilation. Circumcision of male minors is known to often lead to physical and psychological suffering, sometimes death, either as a result of the operation or later suicide. Circumcision has no compensating medical or health benefits for the males who suffer it or for their sexual partners. Ending circumcision of male minors in the UK is my party's #1 campaigning issue. We've held a number of protests in the last year, including the one in Parliament Square, in the course of which I walked across the road for a few seconds, which is why I'm here today. I'm pleading not guilty today because I had a legal excuse for my action. As you all have seen from the video, I was in the road for only a very short time. There are a number of elements to my defence. Number one, contrary to PC Moore's statement, I did not stop in the road. The video evidence clearly shows this. Number two, I was protesting against the failure of the criminal justice system to prosecute the criminals carrying out circumcisions of male minors, as one of the two large placards I was holding made clear. Number three, Article 11 of the European Convention on Human Rights guarantees the right to peaceful protest. The right to peaceful assembly cannot be interfered with merely because there is disagreement with the views of the protesters, or because it is likely to be inconvenient and cause a nuisance, or there might be tension and heated exchanges between opposing groups. Number four, there is a positive obligation on the state to take reasonable steps to facilitate the right to freedom of assembly and to protect participants in peaceful demonstrations from disruption by others. Number five, as there had been no imminent threats of a breach of the police, the police's actions in limiting my right to protest was not done in accordance with the law. It was also an indiscriminate and disproportionate restriction on my right to protest, as there was no reason to view me as anything other than a committed, peaceful protester. Number 6. My right to peaceful protest was interfered with by the policeman in arresting me. The obstruction of the highway was so minimal and for such a short period of time that the arrest was a disproportionate response to the inconvenience to the traffic. Number 7. I turned to case law, and specifically the case of Hurst and AGU versus the Chief Constable of West Yorkshire in 1987, almost 30 years ago. The defendants, both anti-fur protesters, were arrested after distributing leaflets outside a fur retailer and successfully appealed against their convictions for obstructing the highway. I shall now quote from the lead judgment by Lord Justice Glidewell. He said, I emphasise that for there to be a lawful excuse for what would otherwise be an obstruction of the highway, the activity in which the person causing the obstruction is engaged must itself be inherently lawful. If it is not, the question whether or not it is reasonable does not arise. So an obstruction of the highway caused by unlawful picketing in pursuance of a trade dispute cannot be said to be an activity for which there is a lawful excuse. But in this case, it is not suggested that the activity itself, distributing pamphlets and displaying banners in opposition to the wearing of animal furs as garments, was itself unlawful. That's the end of Lord Glidewell's remarks. I would remind you that I was doing something which was inherently lawful, holding placards in a protest. In protest against the failure of the police and the CPS to bring prosecutions for something which is illegal, unethical, unnecessary, physically damaging and breaches human rights, the mutilation of male minors' genitals on religious or cultural grounds. The hypocritical, irrational and disproportionate prosecution of me, rather than of the criminals mutilating male minors' genitals, needs to be recognised and this vexatious prosecution dismissed. Thank you. So, what was the verdict of the lady judge? I should perhaps say that she was sitting alone, and no jury, of course. She bizarrely, to my mind, rejected our grounds for legal excuse, finding me guilty. And we shall, of course, appeal. This is only the first stage in the legal process, and we shall very shortly be appealing for a retrial, a complete retrial, which will be held at Isleworth Crown Court at some point, probably in the next 3 to 6 months. We think the judge made an error, of course, and we will take this as far as is necessary. And we live to fight another day. And I'd just like to end by saying a warm thank you to all the supporters who came here today. A few of them have gone already, having to catch trains and so on. But the remainder of them are here. And just want to say thank you, guys. Thanks, Patrick. Thanks, Richie. Okay. Is that okay?